It is April 6th of 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. If you think your Monday has been stressful, wait till you see today's docket. Judge Stillwell kicks things off with some intense relationship drama, including a messy breakup that involves couches literally being stabbed on top of a car. But stick around for the second half, because Judge McNally's patience gets completely obliterated between a massive fight over a 7-cent rent discrepancy and an attorney caught attending Zoom court while driving to the Final Four. The gavels are coming down hard today, ladies and gentlemen. Grab some popcorn, get a drink, because as always, you know it, it all starts right now.
Call the first case. And that's case 26-000075, Melissa Seeger and Jacob Deaton. Both parties present on Zoom. And we've had no issues with service. So we'll begin with you, Ms. Seeger. If you could please raise your right hand. Do you swear or affirm that the testimony you're about to provide is the truth and the whole truth?
Yes, I do.
All right, go ahead, ma'am.
I am here seeking this restraining order because I was with Jacob Deaton for 8 years. It was 8 years of mental and emotional and physical abuse. There were times that I did try to leave. He'd either stand in front of my car, he would hunt me down. He knew the places that I would always go to escape. He'd show up there, he'd harass the people that lived there. I just could never get away from him. I honestly felt like I was going to be stuck in that relationship forever. I got to the point where I just realized, like, whatever he does to me, even if he follows me to China, it's better than being here with him every day. And so I don't really want to give too many details on how I was able to get out of there. But since then, he has not let me have my belongings. He's holding on to it as this little way to be able to see me. He says that I have to see him in person to get them. He has called my son trying to get a hold of me. He showed up at my work, humiliated me, parked his truck across the parking lot facing the building, intimidating everybody. My boss had to lock the door, letting customers in and then locking the door behind them. The whole time he was blowing my phone up with long messages about how he's gonna take my boss to court because it's illegal. She's locking people in the building and he's watching everything we're doing and recording us. I had to call the police that day to have him told not to come back. Since I've gotten the restraining order, he has contacted me twice. The last time was just a couple days ago. I have it on it says, "I still miss you." I know for a fact if I don't get this restraining order, he's gonna just keep. He's not gonna go away. I mean, when I missed court 2 weeks ago, the only reason I knew I missed it was because immediately after court, he started bothering me and telling me. And he said, "Well, at least if you take me back to court, I'll get to see you." Like, I just want this over. I don't want him in my life. I tried to just break things off with him in a normal manner, and that didn't work. He went ballistic. And
So,
so
hey, Ms. Seeger, I have a
yes,
couple of questions for you. I've got your petition in front of me, and there's what I want to do is run down some of the specific allegations you made and just get a little bit more information about those.
okay.
And then I think that will help me get a better picture of the allegations. But before I do that, where you were just talking, I'd like to actually learn a little bit more. You said that you tried to break it off a couple of times, and that Mr. Deaton sort of persisted on trying to contact you. Can you recall sort of dates and the context of when you communicated to Mr. Deaton that you didn't want any more communication with him, and that you were trying to break off the relationship, and then what happened after that? Are you able to
Yeah.
more
I
specifics
can't
into that?
give you the specific date, but I can give you a roundabout date. Yeah.
That's
Um,
fine.
so 2 weeks after I moved in with him, he hit me for the first time, knocking me to the floor. He denies it. I don't care what he's. I know I was hit, knocked to the floor. At that point, I knew I had made a huge mistake. But I had moved in with him, all my things, given up my apartment. I had no money to move. But I was like, I'm gonna, you know what? I'm gonna stand my ground. And I got in my car and I was like, I'm leaving. And his psycho, he got this look over his face, like he just disappeared. He was just like a weirdo, and he ran outside and he was jumping in front of my car and leaving his driveway. There's just one narrow way to get out, and so every time I would try to reposition my car, he would jump in front of it, and he just had this wild look on his face. And eventually I just gave up because I wasn't going to be able to leave, and I went in. And that's the kind of thing that happened over and over again. But then, so that was 2 weeks, so that was beginning of the 8 years ago. um it was probably about a year after that. Um, I was so depressed. I wasn't myself anymore. And I asked one of my good friends if I could move in with her to get away from him. And he was showing up there too. Um, and
So about a year later, you moved
yeah,
out. Okay.
I tried to. I was only gone for a couple weeks because he was like making my friends' lives uncomfortable. Um,
How would you do that?
and then showing up at their house.
Okay. So
Okay. So after that we moved to a different house, and
you mean you
I
and Mr.
tried, yes. And so I tried to leave him again, and this time I did it. I thought I was doing it stealthily. He was at work. I got all my belongings out that I could get into a car. I went to my son's house where his father owned the home, and thought I was gonna be safe there. Well, I had left my couches at his house. I just figured he can have them. I couldn't put them in my car. I just wanted away from him. He came home from work. He went insane, telling me to get my effing ass home. And he was shaking. He was so angry. He was seething. And I just kept telling him no. I had people with me, so I felt a little bit more safe. But they also weren't the kind of people that would do anything. They weren't going to get involved, kind of thing. So I'm over there at their house, and he comes peeling down the alleyway with my furniture in the back of his truck. And I'm literally like just shaking, mad, screaming for me to get my effing ass home now. And he can't even talk. He's shaking so bad. And he took my couches, full size and love seat and an ottoman, and threw them on top of the hood and the very top of my car and stacked them. And he was slamming them on top of my car. I mean, he has the worst anger issues. He's pointed a gun at me 2 times.
All right. So
He
that's
denies
so.
that.
All right, so Ms. Seeger, I think I'd like to go through some of the specific allegations. And then Mr. Deaton, I know I mentioned, no, I don't want people interrupting. Same thing as far as body language, it's you'll have your chance to respond.
I'm sorry,
right,
but
it's okay. I understand. I'm not asking you to comment. I understand. Just that kind of body language is equally not helping. So you'll have your chance to respond. All right.
Okay.
All right.
You're right.
Okay. All right. So Ms. Seeger, you allege in your petition that Mr. Deaton has pointed a loaded weapon. Tell me a little bit more about that.
At the very first house that I was talking about, where he had hit me the first time, I was on the toilet and we had gotten in an argument, and like I said, his temper goes from 0 to 1,000 just like that, and then he can't think straight. He's just sees red. I don't remember what it was, what the argument was about, but he ran running into his room and got his handgun, and he came charging into the bathroom with it and pointed at me, and his kids were screaming and crying. His son was like 8 years old at the time, and his daughter was like 12, or I think she was like 13 or 14. And his son went running into his sister's room. She was holding him, trying to comfort him. They were bawling their heads off, and he did not care. All he saw was red. All he cared about was, what he wanted to do to me. And I slammed the door and locked it, and it was the scariest thing.
All right. So that was during the course of an argument?
Yes.
Okay. You also say in the petition, next time he hits me, he said, next time he hits
yes.
me, I wouldn't be able to get back up.
He said it in front of my son.
Okay.
So a lot of these arguments stemmed from literally nothing. He can get mad about not finding his piece of pie he left in the fridge. I don't remember what started that argument that day, but he had started, it just takes something little and he goes off the handle. My son was laying on the couch when he said that. My son heard him. And that was actually just before I moved. So that was only like 6 weeks ago that he said that.
All right. So that's so let's fast forward a bit. So recently, if I remember correctly, around the time you filed the petition, you left a shared residence. Can you talk to me a little bit about, again, any communication from you to him, from you, Ms. Seeger, to Mr. Deaton about wanting to leave, and the relationship not having any communication around that time, and then any behavior since then?
So he the things have been like progressively getting worse, even though I don't know how they could get worse. They were getting worse and worse and worse. And I was trying to rack my brain about how, if I could possibly talk to him like normal people do and say, hey, neither one of us are happy. But every time I would even try to start any kind of a conversation like that, he would instantly go off and, I've taken care of you for 8 years, and you're going to do this to me. You're still my bitch. He always says that. You're still my bitch. And so I realized that there was not going to be any way that we would cordially break up. I was just going to have to do it when he wasn't home. And, that's why some of my stuff is still there. I wasn't able to get all of it out.
All right. Thank you, Ms. Seeger. What I'm going to do next is turn it over to Mr. Deaton for some testimony and response. This is your petition, so you have the last word. So I'll turn it back to you before making a decision. So Mr. Deaton, I'll turn it over to you.
All right.
Raise your right hand. Do you swear or affirm that the testimony you're about to provide is the truth and the whole truth?
I do.
Go ahead, sir.
All right, Your Honor. Well, for the past 7-8 months before she moved out, recently, I had been asking her to leave. For one. For two, she keeps telling everyone I have guns. You can send a cop to my house right this second and search all you want. I don't even own a gun.
Oh my God.
So everything she says is exacerbated. She was completely drunk the first 7 years. She physically went after my daughter. I stood up. She's so drunk, she bounced off my chest. I went to jail, even though both my kids were witnesses. I have lost my cool, but I haven't tried to see her. I tried to give her, the last time I tried to see her, I went to her work where she said I was parked across. Well, I was trying to stay out of the way. All I wanted to do was give her her cell phone, the power cord to her TV, brand new TV, and the remote. That was it. I was going to hand it to her and take off. Then I got a call from the cops to not go over there, and I haven't been. Every day I've been hanging out with my buddy Clayton in McClary. And then I came to court, and obviously, if I'm so big and scary, but she couldn't show up on time, and you wrote it off. So I thought the order was gone. And no, her boss and her husband are not coming to my house, because last time her boss and her husband, he's giving me all kinds of looks like he's going to do something to me. She has no proof or evidence of any of her accusations. So I don't understand why my time's being wasted. I want her stuff out of my house. I told her to get a hold of her son, call me, and I'll set something up with him. That's not keeping her stuff. But her boss and her husband are not coming to my house. I'm not going to put my kid's life in jeopardy because she needs people to be her savior. I think we need to have a different court date so my kids can come in and they can testify that I've been asking her to leave. So I don't know what you want me to do.
Okay. All right.
I'm the only one that would bail her out. Sorry, I didn't mean to cut you off. But she's only sober now because she got a DUI, which I had to get up, even though I wake up at 3 o'clock in the morning, go to the gas station where she got pulled over. I got her son to come help me take her car. She's in jail. Everyone in her family, her kids, her mom, her dad, they all said no. They wouldn't go bail her out when it was $100 to get her out. But no, I had to spend my whole paycheck to get her out later that evening. I feel like I'm being slandered here.
Right, so, well, Mr. Deaton, so let's go through some of the allegations.
Okay.
All right, so she, some of the more concerning ones is allegations that you had pointed a weapon at her during an argument. Do you have a response?
It's kind of hard to do that, Your Honor, when you don't own a gun.
Okay. Well, this was, it sounds like
the only weapon I have in my house is a compound bow, and the string's about to break, so you can't even pull it back. So how am I pulling guns on her when I don't even have one?
Saying because you're trying to talk over me. All right.
I didn't mean to. I just.
It's all right. I want to be able to hear you.
Yeah.
It sounds like that may have been a couple of years ago. And so it sounds like you're saying you don't have any weapons now. But as far as this having happened in the past, what's your response to that?
I don't have any guns. How do you pull a gun on someone when you don't have one?
Okay, so you're saying you're denying that ever happened, that you've ever.
I'm denying that ever happened, Your Honor.
Okay.
I have lost my cool, but
Okay.
she's trying to make me out to be the devil.
All right. In reference to when she said, you said something to the effect of, next time that you hit her, she won't be able to get back up. What about any response?
I might have said it.
Okay.
I lose my cool sometimes, but it was more hurt than anger. Like I said, I'm the only one in her life that's stuck by her side at her worst. She literally would drink all night, all day, and then she'd harass my kids about their dead mother. And now I can't even go to work because this is on my record. I was supposed to go work on JBLM, and now my kids' livelihoods put at stake here.
Okay.
Like I haven't even tried to see her. I tried to give her the 3 things I thought she'd want the most because she left it behind. I did run after her when the cops were here when she moved out, but they already took off, and the cops said they couldn't do nothing about it to give it to her.
Okay.
I don't know where she lives.
So, Mr. Deaton, what about she's made a couple allegations about having tried to leave the relationship a few times, but having some difficulty doing that, given some of your persistence. Sounds like the standing in front of her car, things like that. Do you have any response to that?
Your Honor, I stood in front of her car because she was drunk. Like I said, she would literally drink all day. I'd come home, she'd be plastered. I'd go to bed, wake up at 3 o'clock. She's still up drinking after she's been drinking all day. She used to go and destroy my children's stuff, cut my son's hats. She cut all the cords to my vacuum. She cost a lot of money in damage. I've been asking her to leave for the last 7, 8 months. And I ask her, well, why don't you leave then? And she just get this little grin on her face. So you tell me what I was supposed to do. I wasn't stopping her from leaving. Even when the cops are here, they're like, you're going to let her? I'm like, of course. I've been asking her to leave. And what do? I gave her a few minutes with the cops here to get her stuff and get out.
All right.
I don't know what I'm supposed to do. I stay away from her. I do miss her. I do love the woman, but I haven't tried to physically see her or anything. And now, it's like, I tell her son to call me so she can get her stuff, and I'm the animal. I just don't get it.
Okay. All right. Thanks, Mr. Deaton. I'm going to turn it back to Ms. Seeger.
Yep.
Ms. Seeger, a couple follow-up questions for you. So you have asked for protection order. I know sounds like from both of you, there's some issues with some furniture you may have left behind. As far as contact, if the court were to issue a no contact order, then are you sort of giving up that furniture? Would you like some communication, maybe third party?
It's not. No, because all of my I only have my work clothes, one pair of shoes, and a bra. Everything is there. I can't give up all of my clothing, and I've got expensive carpet shampoo there. I've got things I need to get.
Okay, so you would need some sort of communication with Mr. Deaton, even third party, to collect some of your things.
Yeah, I would.
All right. To his, it sounds like Mr. Deaton's response is generally that that he wanted the relationship to end as well, and it sounds like there's an acknowledgement of him losing his cool, but he wanted you to leave as well. And I know the crux of what you're arguing is sort of that he's keeping you in the relationship. It's your petition, ma'am. You have the last word. You can respond to whatever you'd like, but that's top of mind for me as far as his.
I have a few things. I do have a couple things I want to say. So I just wish we never even had to go this route. As far as him saying that he just wanted me to leave, when it's just like, why would I go through all this trouble of having to get a restraining order if he was just going to be a decent human being and let me walk out the door? I mean, come on, let's all think about that. Second of all, the guns. So the way he just sat there straight faced and said that he doesn't have guns, he never had guns, how could that have happened? That right there is a perfect example of why I want far away from him. That is disgusting how he can lie like that. He just recently told me his favorite gun is his AR that he has hidden in his garage. There was, the entire time we were together, he had handguns in the closet that his little kid, his son, when he was 8 years old, he knew how to load them. I watched him do it. And a rifle leaning up in the closet that would fall out every time we'd open the closet door. So the way he could sit there with that face and say that's scary enough right there. And he's under oath. Wow. As far as being drunk all the time, I did have an alcohol problem. He is very much so exaggerating all of those stories. That was just insane. I have been tomorrow I'll have 1 year clean, and it doesn't matter how I got sober. The fact is I am sober. I'm still sober. And that's the main reason I was able to have the strength to finally get out of there. I was drowning myself in alcohol because it was just easier than fighting up against him to leave. I decided I wasn't.
Nope.
No, it's my turn. So I'm not going to go into every little thing he just said. I made some notes, but it's like here nor there. most of what he said was a freaking lie. The only thing that was true was I had an alcohol problem, but he used that, and he's still using that, to belittle me, to keep me down so that my self-esteem would never get up. I was always an effing drunk or an effing nigger. That was his favorite word for me. He said it constantly. And he used to say, well, I'm only mad, we only fight because you drink. Well, I've been sober for a year, and things have just gotten worse. So nothing's ever his fault. But yes, he does have guns, and the fact that he could sit there under oath and lie tells me everything I need. Like, I already knew, but that just solidified it. I'm finished.
Thank you. There's a couple of things I want to take a look at from the file, and then I'll make a decision. So just bear with me here for a few moments. All right. Thank you both for your testimony. I am going to issue a protection order in this case. The reason being, again, I'm going through the factors I talked about earlier, and I do find that Ms. Seeger has met them all. As far as a pattern of behavior, I believe she's established that. I understand Mr. Deaton is disputing much of her testimony. Some things I'm able to look at. I recognize that as far as I can find, Mr. Deaton doesn't have any convictions, but there is some criminal history associated with assault, at least allegations that made their way to the court system with Ms. Seeger as the alleged victim, as well as assaults not involving her, but allegations involving firearm. And these are things I'm able to look at. So I think given the allegations that Ms. Seeger has made, as well as some of that other history, I do think there's a pattern of behavior here directed at Ms. Seeger that at least creates an intimidating or hostile or offensive living situation here. I understand sometimes, folks will phrase it as I've lost my cool. Things of that nature. Ms. Seeger's sobriety isn't the issue here. It's behavior towards Ms. Seeger. And from what she has alleged, what she's provided testimony of, I think I find that she's at least this has had the effect of creating an intimidating, hostile, or offensive living situation that a reasonable person would interpret as harassment, and that would cause substantial emotional distress. So I do find that the elements of the order have been met, or the elements of unlawful harassment have been met in this case. If the parties have ended their relationship, then practically speaking, there's no more need for any communication. I'm not going to put any kind of third party communication here. It doesn't sound like Ms. Seeger has any interest in any kind of further follow-up there. So there's just going to be an order. I understand with respect to weapons, Mr. Deaton is I know you're saying you don't have any firearms.
Yep.
That what you're able to do, and I believe you've done it in the past with some of these hearings, what you're going to need to do is file a declaration of non-surrender with the court file. That was something that was required to do with the temporary order that wasn't completed. I know you told the process server you didn't have any weapons to surrender, but there is a declaration of non-surrender that needs to be submitted if that is indeed the case.
So where do I do this?
Well, you can get a copy of the Declaration of Non-Surrender from the Thurston County District Court website, and how to file it. There's information on that form on how to file it, but then you need to also file it with Thurston County District Court with the civil department.
Okay, one more question. So I can throw her stuff away. I don't have to keep it in my house no more and be reminded of her every day.
Ms. Seeger can correct me if I'm wrong, but it sounds like she has no interest in that property. Is that right, Ms. Seeger?
No, I just told you. He has all of my clothes and I need all my things. He knows that. Now he's saying, and that's another thing he kept texting me was he's taking my stuff to the dump.
That's right. That's right, Ms. Seeger. I apologize. You were clear about that earlier. So what we're going to do is in the order, I'm going to allow third-party communication for the limited scope of coordinating the return of Ms. Seeger's remaining personal property.
Okay, but I'm not a storage facility, and it better take quick, because like I said, I have to wake up every morning, see her stuff. I've been asking her to come get it. I told her to call her son and set up a time to come get her stuff.
He also said that if my son came to get it, I had to be with him.
I want to make sure you get all your stuff. You don't have to come in my house, but you need to be out there to make sure you got all your
this
stuff.
is what I'm talking about. We're not, so what the order is going to do
Your Honor, but
is allow third-party communication.
I'm not going to be able to work now because of this.
Okay.
Like, this is affecting my children's lives. And you guys just think that she says all this stuff. But what's funny is all those cases you looked on file, Your Honor, they all got dismissed because she refused to show up.
All right,
okay,
Mr.
obviously I'm not the big bad guy she's making me out to be.
All right.
You can see his anger issues right
no,
there.
both of you need to stop. I'm signing the order. There's going to be an exception for third-party communication for the limited scope of Ms. Seeger retrieving her property. This will be in place for a year. And after that, there'll need to be a request to renew if that is the case. But at this point, I'm signing that order. And Mr. Deaton, you will need to submit that declaration of non-surrender if that is indeed the case. And Ms. Seeger, you do have that exception for third-party communication to retrieve your belongings, but you will need to get those done. So that's just not hanging out at Mr. Deaton's residence. All right. Yeah, you're muted, ma'am. We had to mute both of you.
I want to get my things as soon as possible, but I don't know how to, because if I have somebody get a hold of him to come get it, because he picks and chooses.
Yeah, Ms.
He
Seeger,
picks and chooses who can go there.
Ms. Seeger, the court's not going to micromanage how that happens. All we can do is say there's third-party communication allowed for that purpose. How you guys go about doing that is up to you.
Okay, so what if he doesn't want the person coming to get my stuff?
Well, I mean, you could, you could come back to court and ask for the court to find him in contempt of the order, allowing you to retrieve your things of that nature.
Right.
There's a contempt of, I mean, that's part of the court order now is you getting being able to get your stuff. So you can file a motion for finding him in contempt of court. Things like that. So that is an option because this is going to be part of that court order.
Okay.
Okay. So I'm going to sign the order at the end of the hearing here, and we'll send out. Do we send out copies?
They usually get them online.
You can just get them online.
Email, I will.
Okay. All right. They'll be available online. Same way you're able to submit response documents for the case. And that will be up later today. And you're both free to go.
Your Honor, her boss and her boss's husband are not welcome at my house. And if I have to file a restraining order against them, I would like to.
Okay.
Like I
well,
said,
you
he
have
come
that
to my house threatening with my kid here and scared my kid. So
Mr. Deaton, you're able to do that. We're not gonna have that fight right now. If you want to petition against some people, you're able to do that too. That's your right.
okay, I will do that. Thank you, Your
All
Honor.
right. Thank you. All right. All right, next we have case number 26-91. That's Brittany McCafferty, and as petitioner and the respondent, Matthew Montero, who I understand are both in the courtroom. And you may be seated. You're welcome to stand, but you're also welcome to sit. I'm just toggling over to this case file. All right. So I won't delay any further. I know you've all been here and sort of kind of understand the process. So what I'm going to do is Ms. McCafferty, as the petitioner, I'm going to swear you in first and allow you to provide some testimony. Then I'll turn it over to Mr. Montero. And for, I think just for you, Ms. McCafferty, because I don't see any responsive documents, but I have reviewed everything in the file. No need to go into, so much of an overview. But so you be confident I've read everything. And so if there's other things you'd like me to know or places you'd like to direct my attention, I encourage you to do that. But that said, do you swear or affirm that the testimony you're about to provide is the truth and the whole truth? Okay.
Yeah, I wrote everything in my petition basically, but I met Matthew on November 24th. And since then, between November 24th, sorry, I have written everything down too for notes. November 24th and March 12th, I think, March 12th, I tried cutting things off with him. And he's been very persistent about keeping the relationship going. And then on March 12th, I cut things off in person. And I told him I was going to block his number. And I also told him he should block my number because he continues to text me after I try to end things or call me. And so I blocked his number. I didn't hear anything on that Friday. And then Saturday, I went to Steel Creek with some of my friends. And then Saturday nights or Sunday early in the morning, like midnight, I woke up to a knock on my door. I wrote this in my petition too. I live in a separate mother-in-law house in my parents' backyard. And I woke up to a knocking on my door, and I saw in the blinds that the motion sensor lights were on the stairs going up to my room. And so I heard a few knocks. Nobody said their name or anything. I contacted my mom immediately and asked if it was her knocking on my door. She said no. And then she looked outside and she saw that the motion sensor lights were also on, but she didn't see anyone out there. But she then saw the motion sensor lights on the side of their house go on. And then she asked if it could have been Matt. And so I unblocked Matt's number. As soon as I unblocked his number, I received a text saying, call me. And I put a picture of that in my evidence too. And so I called him immediately and asked if it was him. He said it was him, and that he wanted to talk, and asked if I was at Steel Creek that night. And I asked how he knew, and he said that his friends had seen me there and texted him that I was there. And then I immediately hung up I told him I had to call my parents back because we were about to call the police because we didn't know who was in our backyard. And so I called my parents back and I let them know what happened. And then I called Matt back, and he kept asking if he could come up and talk to me. He said that he was parking somewhere else so that my parents wouldn't see his car. And then I told him no because it was also 1 o'clock in the morning and I wanted to go to sleep too. But then that same day, just later on in the day, I texted him that I wanted to I wanted him to stop contacting me in person through text. And when I went to the gym that day, I went to park and I saw his car there. And so I went to park. He came to my car and wanted to talk to me. And he told me that he was apologizing for coming to my room that night. And then I had told him that me and my family were going to call the cops on him because we were so scared. And he said basically he could have talked to the cops, or they would have understood the situation. And then there were some other things said too. I don't remember everything. And then I did ask him though if he was going to work out, because if he was going to work out, I would leave because I didn't want to be around him. He told me no, that I could work out. He would work out at a different gym. And so I went into the gym, and about 20 minutes later, he came back into the gym and started working out. And then, so I left immediately. And then he continued to go to the gym at the same time I would go to the gym that week after that. Oh, and I forgot to say this too. On Sunday, when he was contacting me at my car, he told me he went to the church that morning too, which is the church I've been going to for over the past year. And so I feel like he's going to all these different places that I frequent a lot, and he knows that I frequent. And so yes, he continued to go to the gym that week. Tuesday, I forgot the date. March 17th, he came up to me, and I had told some of my friends at the gym what had happened, and just so they can kind of keep an eye and like work out near me. And he came up to me on Tuesday, March 17th, when I had nobody around me who I knew, and asked why he asked to talk to me, and I told him no, to leave me alone. And then he called me crazy and said I was starting drama. And I told him I was going to report him to the front desk at the gym. And then I told my friend who was working out, I told him about this. He came over, and Matt went up to my friend and tapped him on the shoulder right in front of me and said something along the lines of like, I'm sorry that she's bringing you into this drama or something like that. And then Wednesday, I didn't go to the gym at all because of this incident. And then Thursday, he was at the gym with a friend, working out close by. And I just felt like he's going there to, like, at the same time I am, on purpose. I don't know if it's like an intimidation thing or what, but it just feels like deliberate, like he's deliberately trying to go to the gym at the same time I'm going to the gym. I also found out on Thursday that he was at Steel Creek through some photos I found on Facebook. He was there the same night I was there, but he never said anything about him being at Steel Creek that night. He told me it was his friends that saw me. And then, so Friday, I decided to petition for this restraining order. And then one other thing is I called the police department on Tuesday following the last hearing I was at, to check the status of the service. And they told me that he had been served the day before on Monday night. And they told me that he had told the police that he locked his weapons up because there was an order to surrender weapons. The police told me that he told the police that he had locked his weapons up on base, but they didn't tell me how many weapons or where they were locked up. So I called Thurston County, the non-emergency number, to check about this, because I included pictures, but I know he has weapons where he locks in a safe at his old apartment that he still has access to. And I haven't heard anything back about whether those have been surrendered or not, but I've included pictures of those weapons. And yeah.
Thank you, ma'am. As you saw previously, so what happens next? I'll swear in Mr. Montero for a response, and then this being your petition, you'll have the last word before making a decision.
Okay.
So, Mr. Montero, please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
I do, Your Honor.
Okay, go ahead, sir.
Before I sit down, I know I didn't submit any evidence online, just due to work and personal life. I have my statement and screenshots of text messages. It's not a whole lot.
Well, you're welcome to read your statement. I mean, that's just your testimony. I can't consider anything that Miss McCafferty doesn't have notice of. So to the extent you're showing up with something new, some kind of new information, that's nothing I can consider.
Yes,
but as far as a statement you've prepared, things like that, that's
how about witness testimony?
So witness testimony from non-parties is allowed only if the judge finds that their testimony is both material and necessary, so relevant to the allegations and necessary in order to come to a conclusion, come to a decision.
Yes, Your Honor.
And so you have a witness today?
I do. He's actually present. He's right behind me. Your Honor.
Okay. So one thing you might do is in your testimony, explain to me what your witness would talk about.
Yes, Your Honor.
And then I can make that decision and
Yes, Your Honor.
we can go from there.
Understood.
But yeah, as far as you've got a statement, go right ahead.
Yes, Your Honor. Okay, so first and foremost, I would like to sincerely apologize to petitioner's parents, Brenda and Mark, for the stress and inconvenience I have caused. That was never my intention. I also want to express that my intentions toward the daughter, Brittany, were always genuine. Never intended to make her feel unsafe.
So if I may stop you real quick. So I think I understand what you're kind of doing. You're trying to address. We still want to make sure you just address the court.
Yes, you are.
So what you may want to do is just let me know your feelings towards your intentions and things like that without addressing other people directly.
Okay.
Yeah.
Okay. Yeah, it was never my intention to feel the petitioner unsafe around me, and I believe she can acknowledge that. I do apologize for the stress, inconvenience, and fear that the petitioner expressed in her statement that I read. I take responsibility for my actions, the impact that had. I want to make it clear that nothing like this will happen. Again, I cared deeply about the petitioner, and I would never intentionally jeopardize her safety. Yes, and this whole issue started on Saturday, March 14, 2026. My friends Tyler, Stephen Linman, Javier Vargas, and Ian Hubbard and I had plans to go to Steel Creek in Tacoma, located at 1114 Broadway, Tacoma. Earlier that evening, I communicated with Tyler, who is my press witness, Your Honor, via text messages about arrival times, and he later informed me that the petitioner was there. I expressed that I did not want to create an uncomfortable situation with her, with my friend Tyler. I arrived at Steel Creek at approximately 22:30 hours and remained with my friends the entire time. I did not see the petitioner while I was there. During that time, I consumed 12-ounce Modelo beer while I was talking to my friends about my relationship with the petitioner. I expressed my regret for not fully committing to the petitioner when I had the opportunity and shared that I wanted to work things out with her. That was the reason why I kept the persistency and wanting to work things out with her relationship, because I felt like I was behind when she was fully committed to it. But yeah, the biggest thing that got me and realized that I wanted to make things work with her, because she expressed her feelings about my son, Rylan, and she even said that she would treat him as her own when we were still in good terms. Around midnight, 13 hours, I decided to leave. As I was leaving, I made a decision to go to the petitioner's residence to speak with her. In hindsight, I recognized that this was a poor decision. I should have waited approached the situation at a more appropriate time. When I arrived, I parked in the same area where I had parked on previous visits, which is in front of their neighbor's residence, one house over southeast of the petitioner's parents' residence. I entered through the side yard wooden gate, which I had used multiple times before during our relationship. This door is a wooden built door, approximately 6 feet tall, with a hook latch that is never locked. The petitioner lives on the second floor of a detached home that was built by her family, I'm sorry. I approached the door and I knocked approximately 4 times and received no response. I left the premises shortly after. Please note that there was no forced entry, and I left the side yard wooden door shut and closed. A few minutes later, the petitioner called me and asked if I had been at her door. I confirmed that I had and immediately apologized. I explained my intention was simply to speak with her. She stated that she was frightened and had contacted her parents. And again, I apologized and I asked her to extend my apology to them as well. I asked if she would be willing to speak in person, but she declined and said she would think about it and follow up later that morning. I did not contact her throughout that day and gave her a space that she needed. On Sunday, March 15, at approximately 11:23 hours, I received a message from the petitioner stating that she was no longer interested in continuing the relationship and that my showing up unannounced had frightened her. I responded with an apology and acknowledged that showing up that time was inappropriate and reassured her that I would never jeopardize her safety as before. I would also like to address the concern that I've been following or appearing wherever the petitioner is. I have listed the addresses here just for you, Your Honor, to see that my ex's residence is in the city of Lacey and my son goes to a daycare nearby. I have attended services at Capital Christian Center located at 4431 Martin Way in Olympia. And that's because when I started seeing petitioner, she invited me to go to church with her sometime early December 2025. And from there, I started going to church, including before this incident and not in relation to her. I also regularly go to LA Fitness located at 1200 Galaxy Drive, Northeast Lacey during consistent hours for my personal fitness routine. On March 15 at approximately 1600 hours, I was in a parking lot of LA Fitness. She stated this earlier in her statement. I was at the parking lot. I had just dropped off my son to her mom after I went to church that morning at 11:30. And I dropped my son off at 1400 because I had to eat lunch with my son. And I dropped him back off at her mom's place at Modera. I'm not going to disclose that address for personal safety. And I explained my intention that, just backtrack. I decided to approach the vehicle as soon as she saw me. And I apologize again for my action the night before. I explained my intention and acknowledged that I could have handled the situation differently. And she indicated that I should have had approached things another way. After our brief conversation, I offered to leave so she would feel comfortable without me being in the gym. I initially attempted to go to another gym, but I was unable to access it because my friend was not at the gym and he could not get me a pass. I later returned to LA Fitness after over an hour and not 20 minutes after, as she stated. My intention was not to upset or disturb her, but simply to continue my normal routine. I acknowledge that I made poor decisions, particularly in going to her residence unannounced at a later hour. I normally call her or text her when I'm on the way, but at that time, I believe my phone number was blocked. I should have known better. I take full responsibility for those actions. And I also recognize that I became overly focused on that relationship, which affected my judgment. Throughout the relationship, I believe we were on good terms as we continued to spend time together, including shortly before the incident, Monday, March 9, 2026. She wanted to go to the mall. We went to the Como Mall, Costco for groceries, grocery outlet for more groceries. Then we came back to my house in DuPont. She even helped me with my groceries after. And on Tuesday, March 10, 2026, we were at the gym chatting and doing our own workout routines. So we do go to the gym at the same time because of our work hours. I do get off work randomly from 1500 or 1600. If I don't have to pick up my son from the daycare, then I would go to the gym right away. On Wednesday, March 11, 2026, we were at the gym chatting and doing our own workout routines. Also, I invited her over for dinner. I came home to my house and cooked dinner for us. She came over after she finished her workout. And on Thursday, March 12, 2026, we were at the gym again as usual times because that was my regular routine as well. And after I finished working out, I asked Petitioner she would have a heart-to-heart conversation with me. During that conversation, she decided to end things, and I kind of agreed. As she was leaving, she said if I wanted a hug, I said no. I jokingly told her I would have to block you because I did not know what else to say. Now I understand that my action caused distress, and for that, I truly am sorry for that. I would like to provide a timeline for the week following the incident. On Monday, March 16, 2026, at approximately 17:45 hours, I pick up my son from my ex's partner's residence. That same day, I went to the gym with my friend Tyler, who was present today, Your Honor, as a witness. I brought my son with me. and checked him into the gym's kids club area while we worked out. On Tuesday, March 17, I had a conversation with a female friend from the gym. I will not name her, as she said that she did not want to get involved. She mentioned that she did not want to be, quote unquote, in the middle of any drama. I was confused, and I asked her what she meant, but she declined to elaborate and advised me to let go. I have a screenshot of that, Your Honor, if you wanted to see that I was told by this female friend from the gym that there was a word going around about me.
Again, that's not something I can take.
Understood, Your Honor.
You've described it, so that's.
This led me to believe that the petitioner may have been discussing our personal matters with people. Later that day, after my workout, I saw the petitioner, as she stated earlier. I approached her at the gym, calmly and respectfully, to ask what she may have been telling people. As a father, I was concerned about bringing my son into an environment that there could be negative perceptions or misunderstandings about me. When I spoke to her, she became defensive and contacted her friends, including Alfred, who is listed as one of her witnesses. I addressed him briefly and stated that I was not trying to cause any issues and that I was simply seeking clarification on what was going around, and if I could ask her to stop saying things, but because at that point I was over our relationship and I was ready to move on. The petitioner declined to speak with me further, and I left the area. At approximately 20:54 hours the same evening, I received a text message from the petitioner instructing me not to contact her again and stating that she would pursue a protection order if I did. I responded by expressing my concern about what was being said about me at the gym, particularly because I bring my son to that kids club. I also stated that I was over pursuing our relationship. For the remainder of the week, I continued. This is a continuation of the timeline after the incident, Your Honor. For the remainder of the week, I continued to attend the gym, either alone with my son or my friend Tyler. I did not attempt to approach the petitioner again. On Monday, March 23rd, 2026, at approximately 17:30 hours, I was at the gym when the staff asked me to speak with them. I met them at the desk, and they informed me that there was a complaint made about me. Although they did not disclose who made a complaint or the specific details, they gave me the opportunity to explain my side of the situation. I provided them an account of the events, and afterward, I was allowed to continue my workout and continue my membership. At approximately 18:04 hours, the same day, I received a phone call from my housemate from DuPont informing me that a police officer from DuPont PD was at our residence looking for me. I informed the police officer that I was at the gym and I would meet him at the DuPont Police Department after my workout. I arrived at the station and was immediately served with a temporary restraining order filed by the petitioner. Upon being served, I felt deeply disappointed and recognized the seriousness of the situation. The officer asked whether I owned any firearms. I confirmed that I do. However, all my firearms were already secured at my unit's arms rooms at JBLM, located at 3653 Stryker Avenue, JBLM, Bravo Company. I decided to bring all my firearms into that arms room because I had no other place to place them when I moved out of my old apartment in the city of Lacey. I stopped going to locations.
Can I ask you a question about that?
Yes, Your Honor.
So is part of your military duties to possess?
Yes, Your Honor.
You possess firearms as part of that?
Yes, Your Honor. And I will include that into my statement. I'm sorry. I stopped going to locations I previously frequented with the petitioner after I was served in the Lacey area, including the gym and other public places that we used to go to together. The only reason I now travel to Lacey is to fulfill my responsibilities as a dad, specifically to visit and pick up my son from his mom's residence and from his daycare, located at 2420 Marvin Road, Northeast, Lacey. I have made every effort to comply fully with the order and to prevent any further contact, misunderstanding, or actions. And I'm actually in the process of moving further away, which is in Puyallup area, so I won't have to cross paths with the petitioner again. I would like to add that I did not intend to make the petitioner feel uncomfortable or threatened at any point. I respectfully that my character, after I read her statement, I felt like my character was attacked. I just respectfully ask that my character and integrity, particularly in my profession, not to be undermined. I take great pride in my service and the responsibilities entrusted to me, and have consistently achieved those standards. At no point have I taken advantage of my position. I have received multiple, I don't know if it matters, but letters from our captains, lieutenants, and colonels, which reflect my professionalism, conduct, and dedication to taking care of my soldiers and making sure they are welfarely good. I understand the seriousness of this matter, and that court must take its based on the court must make its decision based on the information presented from both parties. However, I respectfully ask for both the petitioner and the court to consider broader impact this situation may have on my future. My military career and career path are at stake. I am currently in the process of pursuing officer candidate school to meet the rank of second lieutenant, and I was scheduled to attend training in Georgia later this year. At this time, have been flagged by the Army, which prevents me from promoting or transferring or leaving JBLM. This situation may affect my eligibility to attend OCS, and additionally, any restrictions related to firearm possession directly impacts my ability to serve in the military and could jeopardize my continued service. I am concerned about the long-term consequences this may have on my career benefits and future opportunities. The petitioner knows how important it is for me. She even helped me and kind of reviewed the process when I was building my packet for OCS. Beyond my military service, I intend to continue serving the community by pursuing a career in the fire service or go back to the police department after completing my military obligation. I respectfully ask the court to take these factors into consideration. And that is it, Your Honor. I don't know if you still consider hearing the statement from my witness or not.
All right, thank you. So my understanding of your witness would essentially be to talk about this issue with the steelhead in Tacoma and whether or not it was your intent to be there to monitor, or if you were going otherwise beforehand.
Yes, Your Honor. And I have the screenshots of our text messages.
Okay. I understand that's I don't think that's necessary or material to hear from a non-party here. I understand that's your testimony. That was your reason for being there. I think in the broader scope of the allegations, I don't think that any outside third-party testimony rises to the level of it being necessary and material for making a decision.
Yes, Your Honor.
So I understand what you're saying. I understand the testimony you provided on that front. So I'll take that into consideration.
Yes, Your Honor.
And thank you for your testimony. I don't have any follow-up questions for you. You answered my question about,
yes, Your Honor,
about the military duties. Ms. McCafferty, this is your petition, so you'll have the final word.
About the gym part, before the first time I ever met Matt was November 24th. I've been going to LA Fitness in Lacey since I think 2017. I've never seen him there at that time. I'm also aware that he has a bunch of different gyms on base that he has access to. And then he said, I think he has a membership to West Coast. I don't know if he has a membership or his friends get him into West Coast. But he also had told me in the beginning, or not the beginning, but some time that he used to go in the mornings at LA Fitness, or he would sometimes go in the mornings. But I go to the gym almost every day at that same time, and I've never seen him before November 24th. About the child on March, it was Monday, March, sorry, hold on a second. March 16th, he said he had brought his son to the gym for childcare. He had never brought his son to the gym, and I kind of feel like that was like a manipulation tactic because he knows how much I do love kids. It felt like he brought him there because he maybe thought I would want to talk to him if his kid's there. But I had never seen he had never brought his child to the gym before that. And when he brought him to the gym, he would walk him back and forth several times from the front of the gym to the locker rooms. So you go through the whole gym, and I believe he was doing that on purpose, so I would see his son. And then in regards to the firearms, he said that he locks his weapons away on base, but he has access to the old apartment, the Madero apartments. He used to live there before he had moved to DuPont in March. And his ex-wife lives in those Madero apartments now, and they share custody of the child. And I believe he has access to those apartments where there's a safe that he keeps his weapons in a closet, because I've seen the safe before. And I believe I know he has at least 5 handguns and a rifle, but I don't believe he keeps on base. I believe he keeps those in the safe in the apartment. And then, yeah, I can't think of anything else.
All right, thank you, Ms. McCafferty. All right, well, again, I appreciate everyone being here in your testimony today. I am going to grant the order. I find that Ms. McCafferty has met the elements that I went over at the beginning of the hearing, at the beginning of the calendar today. Mr. Montero his testimony has expressed sort of his intent behind some of this conduct and this communication. As I said at the beginning, what the court is looking at here is how a reasonable person would interpret the behavior or the communication. And so, notwithstanding, Mr. Montero, your intent behind the reasons why, you went to the mother-in-law cottage or continued with communication, the court is looking at how that is reasonably perceived from the perspective of the petitioner, Ms. McCafferty, but also how a reasonable person would interpret that. And based on what's been filed, based on the testimony, recognizing you've provided testimony about your actual intent, the court does find that a reasonable person would interpret that behavior as unlawful harassment and would suffer substantial emotional distress. I believe Ms. McCafferty has demonstrated her actual substantial emotional distress through some testimony provided by her parents, as well as testimony about changed behavior in response to this. I believe Ms. McCafferty has indicated there's a couple of dates in March where I think there was clear notice being provided to cease communication, after which communication persisted. I understand there may be some dynamic back and forth a bit, but I think between some of her statements about any communication, ending the relationship, any kind of response to Mr. Montero's reaching out about trying to fix the relationship or things of that nature, I think that testimony does show that that at least had the effect of creating an intimidating environment for Ms. McCafferty. So I believe she's met the burden of proof for the 6 elements of unlawful harassment here. I am mindful of I think your words were sort of the broader implications of this. Under the law, once a party is subject to a protection order under the statute, that does come with an order to surrender weapons. And I understand that may have some impact on your military career. There's a couple of ways you can go about complying with that. The order requires you to not have access, custody, or control, or obtaining, possessing any firearms. So you can work with JBLM as far as if they can sort of attest to all of your firearms being out of you not having access or control over those because they're at an arms room. That may work. Otherwise, you'll need to submit those to the DuPont Police Department, and and file a proof of surrender and a receipt that those firearms have been received. These orders are in place for a year. And so, if Ms. McCafferty wishes to have that extended, we'll come back to court to see if there's been any change. But for the time being under the law, I believe Ms. McCafferty has met her elements, and that an order to surrender weapons is therefore appropriate. So what I'm going to do is I will sign the order. What I wanted to carve out, I want to mention is, I know there's been a lot of talk about the gym as well as the church. One thing, Ms. McCafferty, what I can't necessarily do is restrict where Mr. Montero goes sort of unrelated to you, especially when we start getting into churches and things like that. So I'm not going to put any distance restrictions on specific places unconnected to you. What both parties may have seen in the petition is there's an exclude and stay away from provision in which Mr. Montero would be prohibited from knowingly coming within or remaining within 1,000 feet. And so that's going to, that will be in effect for you personally. So, if the two of you do frequent certain places like LA Fitness or a particular church, that's going to be on you, Mr. Montero, to recognize if she's there. Again, it's knowingly. So if you see she's there, you're not, it's unintentional. You see her there, you're not suddenly in violation of the order, but that does mean you'll have to leave. There's also, though, the only time we do have a specific, you are not to go within 1,000 feet of a certain area is her residence. So that sounds like she's at the mother-in-law. Now, wherever her residence ends up being, that it follows her. If she changes residence, that 1,000 feet remains in effect. I won't go over the order in too much more detail. You'll both be able to have copies of it. With respect to the steelhead bar issue, I think that was around allegations of stalking, essentially. I'm not making a finding of stalking. I think given that it sounds like the two of you do frequent very similar places, at this point, I'm not making an extra finding that there's been stalking involved. That the difference there would be, another provision in this order, prohibiting you from essentially putting Miss McCafferty under kind of surveillance and things of that nature. I don't think that the elements have been met for that. So to the extent you are prepared here to provide testimony in response to those allegations, I'm not finding that those elements have been met. But that's separate from the lawful harassment piece of it. So again, do you have any questions about that, Ms. McCafferty, as far as I know you put in the petition, I think specifically LA Fitness in your church as places you didn't want Mr. Montero to go. I'm not going to put those places specifically as far as restrictions, but there will be that 1,000 feet restriction, and your residence will have a specific restriction. Do you have any questions about either of those things? Mr. Montero, do you have any questions?
No, Your Honor. I just want to clarify. You won't see me. She won't see me there.
Understood.
Yes.
Yeah, understood. Okay. You can both get copies of these orders. They're on the Thurston County District Court website. Final orders will be prepared later today. So, Mr. Montero, as far as next steps for you, is complying with that order to surrender weapons. Again, take a look at it. It explains, that order does explain the different ways you can comply with it. Do we send them as part of the packet, the declaration of non-surrender and the proof of surrender, so we can
Yes.
Okay. All right. So part of the packet. All right. So part of the packet, sir, is that you may have received already is the declaration of non-surrender and the proof of surrender. Between the order to surrender weapons and those two documents, it explains how you go about showing that you're in compliance with that court order. And so if you have any questions about that, you can
I have a quick question. I don't know if you can answer it. So how do I go about it if JBLM already has custody of my firearms?
Right. So, that's one thing I would encourage you to call the non-emergency line for the DuPont Police Department. One thing that they may need from you is, so you would basically essentially then be filing a declaration of non-surrender, but there would need to be some sort of evidence from JBLM that where your weapons are stored, you don't have control or
Which I
custody.
do. I have a copy of like serial numbers and certain firearms that's on that document, so I can
yes.
just attach it.
Yeah. So send that to DuPont Police Department. And to the extent those are your only weapons, that may work. Talk to them. If there are any firearms at your residence, those will either need to be stored in an area where you don't have custody control or access, or turned over to the police department.
Understood.
Call them a non-emergency line. They can help you with that. And then if you do file a declaration of non-surrender, you'll need to also file that proof that JBLM or whoever has access, custody, and control of those is able to demonstrate that, in fact, you don't have access, custody, and control of those weapons.
So, and what's the time gap for me to do that?
Immediately.
Okay.
Let's see here. You'll need to go do that within 24 hours of the order. So that will kind of be your next steps, is contacting them and getting that submitted.
Yes, sir.
All right. Thank you both for being here. You're both here. And one thing, when all parties are present and there is an order in effect, one thing that I know it's stifling hot in here is that if we try to have the parties leave separately. So Ms. McCafferty, whenever you're ready, we'll let you leave. And then Mr. Montero, you're free to stay a few more minutes. And then,
yes, Your Honor. Appreciate it.
LaCrystal Lovett, 2601171.
Good morning, Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor.
Ms. Lovett, your name, ma'am?
LaCrystal Lovett.
Did you listen to and understand the rights on the video, ma'am?
Yes, I did.
Do you wish to speak to an attorney or
No,
apply for funding?
no.
All right. Why don't you give me your breakdown now? Let's start with rent to retain.
$1,180.07. $175 late fee and a $75 statutory attorney fee for a total of $1,330.07.
Is the past due rent 118007?
Yeah,
So where's your court costs?
they were paid.
What do you mean they were paid? I'm not understanding. Why am I not getting rent to retain and then the court costs?
I did. I said it was $1,180.07.
Is that the amount of rent that they owe?
Yeah,
So what are you doing? Are you guys saying that they're paying the costs before they're paying the rent?
they paid the cost and the rent in March, and now it's April the 6th.
Judge Mueller, writ date will be April the 16th.
Do you want to ask her whether she can pay that?
I'm just not sure how I'm confused. I mean, I've been doing this for 32 years now, and you guys, is your ledger crediting the court costs before the rent?
Our ledger credits the oldest amount due. So when she went into April, she only owed 7 cents, but it's April the 6th now. So we didn't dismiss the case. So now she owed that 7.
Wait a second. You're telling me, Ms. Lovett, why don't you unmute? You're telling me she only owed 7. When did you pay the amount that was due according to them, Ms. Lovett?
I paid the remaining balance for March on the March 31st. So that I could go into April just
You
on
owed
April.
7 cents.
I didn't know I owed 7 cents. I was told I owed $221, so that's what I paid on the 31st. which was the remaining balance for March.
So they're entitled to their court costs. I'm confused still, Ms. Cohen. Maybe you can help my brain here because I'm confused. If they paid and Ms. I'm sorry, I forgot your name, Hampton's manager. How are you?
I'm good. It's Katie.
Yeah, Katie what?
Katie Sprout. Katie Sprout, I'm sorry.
So you're telling me, so I want to know from you, was everything paid up by the end of March?
Okay.
Except court costs? Or were the court costs paid?
Okay, give me 1 second. I have to pull up the ledger.
You're muted again.
My maintenance guy was talking to me. I told him to go away. I'm sorry.
That's okay. I want you to tell me what the balance was as of March 31st after she made what I think she said was a $221 payment. What would the balance have been?
It would have been the 7 cents as of the 31st.
I mean, basically, she's paying off everything, but we're not dismissing the cases because
Did she pay the court costs? Does that include it in the 7 cents?
I don't believe so, no.
Yes, everything was included. That was my breakdown that I got.
Second, I want somebody to give me a good answer to this question. If you're telling me she only owes 7 cents, not including court costs, that's one thing. If you're telling me she owed 7 cents, including court costs, in other words, she paid everything and just had a balance at the end of March for 7 cents, which of those is true?
That's correct. She paid the court costs, everything but 7 cents.
Well, I'm not going to give you guys a judgment
That's
then.
fine. I'll dismiss it.
Well, you guys got to tell me this, though. I feel like I was just a dentist. I didn't go to dental school.
Okay,
I
I'm
mean,
sorry.
Come on.
Move for dismissal.
You didn't do that on the last one, did you?
Here's the issue, and I'm not sure. I'd have to go back to the last one and see if there was but I mean what the judgment says is that, or the court rule says, is that we're on the date of the court that we're entitled to collect everything that's due at that time. And the issue is, let's say
Listen, if she paid everything but 7 cents, there was nothing due as far as I'm concerned. That was an accounting error probably on the behalf of the management. And if she's paid everything in full by March 31, nobody's coming in here and getting a judgment from me for the rent that's due on April 1.
Okay.
It's not even a close call, you guys. That's why I was confused with this.
Okay. All right.
No court costs or the court cost. I want to know the first thing out of every lawyer's mouth, if you guys can hear me. Rent to retain, how much is it? Late fees, how much are there? And then you can, I don't mind if you include all the court costs together, including statutory attorney fees. So are you moving to dismiss, or do you want me to do this on my own, Ms. Cohen?
I'll move to dismiss.
Case dismissed, motion of the plaintiff. Let's see here. Creekside versus Amber Matisse, 2600998.
Good morning, Your Honor. Daniel Landman, P35797, appearing on behalf of the plaintiff. Ms.
Morning,
Matisse
Mr.
is
Landman.
present.
Hope you had a nice trip.
It was wonderful. Thank you.
Good. Ms. Matisse, can you just stop right there, please, and tell me your name, ma'am?
Yes, Amber Matisse.
You made application for funding. You provided us with proof. Have you heard from the funding agency?
No, but I did pay it all in full a couple days ago.
Is that true?
Your Honor, I don't have any information to that effect, and if she did pay it in full a couple of days ago, it would have been over the weekend, so we would not have heard.
Ms. Matisse, you have a
Sir,
warrant for your arrest, I'm told here. Ms. Matisse,
Okay.
do you have anything else, Mr. Landman,
I do
today?
I have two other cases, Your Honor, at 9 o'clock, yes.
Why
One for Deerfield Estates, one for South Glen.
why have you not taken care of your business here, ma'am?
I was trying to make sure my kids had something stable first, and then I as soon as my kids are, I'm good with my kids, I plan on fixing all my wrongdoings.
How old are those?
So sorry. Excuse me, Your Honor. I didn't mean to interrupt, but I did just want to verify that Miss Matisse did pay her rent in full over the weekend.
In that case, Your Honor, we will move to dismiss without prejudice, and I'll submit a proposed dismissal.
Thank you very much. Ms. Matisse, I
Yes.
expect you to come up here this morning and take care of your warrant. You understand what I'm telling you?
Yes.
I mean, I don't want to have to call the police and have them come to your house and arrest you. So come on up here to the courthouse. I'm sure it'll work out. Is that mine, Heather, or Jennifer? Can you tell?
It's Judge Heston's, Your Honor.
She's nicer than I am. Come on up here today. Good luck, Ms.
Okay.
Matisse.
All right.
Come up here today. You understand what I'm telling you, right?
No, I understand. I have to get somebody to sit with my kids is the thing. I have to figure out my kids before I can come up and do a court thing.
How old are your kids?
Huh?
How old are your children?
They range from 10 to 2, and I have 5 of them.
Are some of them in school?
Yeah, they don't have school today though. I just walked up to the bus stop and we sat up there for 10 minutes.
Yeah, I'm sure it'll work out, Ms. Matisse, but you have to show up in court. You understand what I'm telling you? Judges
Yes.
don't like that. All right, good luck.
No, I understand. Thank you.
If you can't make it today, make sure you make it tomorrow. We're gonna keep the warrant in effect until you show up, though. That's gonna be embarrassing for you. If you get picked up on a traffic stop and you end up in jail overnight, you don't want that, right?
No,
Okay.
no, sir.
All right, we're not that bad, but you gotta show up in court, all right?
Oh, okay, yeah, I'll
luck,
figure
all
out
right?
something for my kids and I'll get up there.
All right, good. Thank you. All right, Golden Management. Golden Management versus Luella Morgan and all occupants. 2601133.
Good morning, Your Honor. Sarah Lowney on behalf of the plaintiff.
Good morning, Luella Morgan.
All right, what are we doing on this one?
Yes, Your Honor, I did have a chance to speak with Ms. Morgan today, and we have worked out a consent judgment. This is a health hazard case. So
Good.
Ms. Morgan, I believe at the last hearing indicated to the court that she would be cleaning up the property. From my understanding, it's not been remediated yet. So we did just agree to a consent judgment for April 16th. She shall fully clean the property, repair any damage, and coordinate an inspection with plaintiff before that date.
So she's gonna vacate by the 16th?
If she does fully remediate the property and clean everything up, my client would give her an opportunity to stay.
Well, how you want me to word this? I mean, what are we gonna do here?
I can just put it in the further terms that the April 16th shall be the date. But if she does coordinate that inspection, repair the property, then she shall have the ability to stay. We won't apply for the order of eviction then.
You guys are kind of playing judge and jury there, aren't you, though, Ms. Lowney? I mean, it just seems to me like you're saying the 16th, she would have an order saying she has to be out by the 16th. And I don't know what the provisions are gonna be in the consent judgment. What are you gonna say? You guys are gonna inspect? And if it's not to your satisfaction, she has to get out. If it is to your satisfaction, I don't like doing it that way. I mean, if you want, I don't know what to tell you. I mean, ma'am, if you sign up for a consent judgment for April 16th to vacate with this proviso that if it's done to their satisfaction, they're basically going to get to play judge and jury, and I don't like that. can I make a suggestion, Ms. Lowney?
Yes, of course, Your Honor.
Maybe you can just say, that you're going to give her until the 20th. And you guys can coordinate going in there. And if it's not done to your satisfaction, you can come in and tell me on the 20th why it isn't, and I can give you a judgment with a writ date that you are requesting. I mean, this is health hazard, so you do have the right to immediate, but the point being that I'm just not feeling comfortable with you guys going out, you saying April 16th, she has to vacate. But then if it's done to your satisfaction verbally, I mean, it at least needs some judicial oversight is what I'm trying to tell you nicely.
I understand, Your Honor. Well, my concern is just that this property is not passing city inspections as it is right now. So that should be, could we do like a conditional dismissal or something like that? Or the same issue would arise?
Do a conditional dismissal and dismiss it, but I think it in fairness, if there's a question as to what she's done, you're going to need me to decide whether or not it's still
Understood, Your Honor.
The property's in a hazardous condition.
So April, when would be the next hearing?
I can give you one. I'm not quite sure what you're asking. I could set it for the 20th. I can set it for, I think, the 13th, right, Jennifer?
We have the 13th, 20th, or 27th.
Yeah, I mean, but how you gonna word everything, I guess?
Well, Your Honor, I can prepare an order today. If she does fully clean everything up by, I guess, the 20th, we'll come back here, or the 16th, we'll have our hearing on 20th just as a control date. But if it's not fully clean by that date, then I would just be asking for a judgment and an immediate order of eviction to enter. So today I would just prepare just an order that we'll have another hearing and that she shall clean everything by the 16th, repair the property.
If she doesn't, then you guys can present evidence and I'll listen. Is that what you're saying? And I'll decide whether or not it's in a hazardous condition?
Correct, Your Honor.
Ms. Morgan, do you understand what she's telling you?
Yes, I do, and I appreciate you taking this into consideration. I appreciate it.
Well, I want you to understand that the conditional dismissal is going to say that you have to clean up the property free from all those contaminants. I didn't read it. I don't know what it is.
Yes.
What is it? By the 16th. And if you don't, on the 20th, we're going to have a hearing and I'm going to determine whether or not you've complied. And if you haven't complied, I'm going to order you to be evicted. Do you understand that?
Yes, I do, Judge. Thank you so much.
Ma'am, do you have somebody that can help you?
Not really, but that is a lot of time for me to get it off, and I have my work schedule available that I'm off work, so I'll be able to get it done. A lot of it is just books and paperwork that I need to go through and throw out.
Okay. So you're going to prepare, I just want to be clear, conditional dismissal that says she has to complete the cleanup by the 16th. We're going to reconvene on the 20th. If it is not to the landlord's satisfaction, we're going to have a hearing and I'm going to determine whether or not the property's been cleaned up properly and order an eviction. Is that true?
That's correct, Your Honor. I wasn't going to prepare a conditional dismissal. I was just going to prepare just a standard order, just stating that we'll have a control date of the 20th and that the 16th would be the date to have everything cleaned up. And then if we come back here on the 20th, everything's fully cleaned, and we can just dismiss the case then. But if not, then a judgment and an order of eviction would enter at the same time.
Okay.
Okay. Perfect.
Thank you, Ms. Lowney.
Wait a minute.
Thank you.
Hold on a second.
Yes.
I'm troubled by that. We're not going to have you're not going to submit a conditional dismissal now?
Well, then I would have to just, if she doesn't clean everything up by the 16th, I would just have to reinstate the case. And then but we have the other hearing scheduled. I will do whatever the
Why
court.
don't you schedule this for the 20th and you guys understand and agree that it has to be done by the 16th, and that if it isn't, and it's still in the same condition on the 20th, you can just move for judgment then. Does that not make more sense?
That works for me, Your Honor.
Let's do that. April the 20th. April the 20th. Jennifer, at what time?
10 o'clock,
9:30?
Your Honor.
10 o'clock, okay?
Perfect.
April 20th. Make sure you get that cleaned up, Ms. Morgan, okay?
Thank you so much, Your Honor. I appreciate you taking your kindness on me.
No problem, but I'm looking at some of these pictures. You got to get rid of this junk,
Yes.
okay?
That's clear. Oh, it's almost all gone now anyway.
All right, good enough. Good luck. Thank you.
Thank you for your kindness.
Thank
No
you.
problem.
Bye.
Roger Allen LaBelle, 19F231701.
Judge Matthew Gate, and after Mr. LaBelle.
Mr. LaBelle, your name? We're not hearing a word.
There you go. Try it now. Oh, yes, Roger Allen LaBelle.
Where's he from? I hate to inconvenience anybody, you know what I mean?
I understand.
No, it's fine, sir.
Inconvenience
I'll tell you
anybody.
when to talk.
Like I said, we're gonna be doing these on boats and golf courses pretty soon. Where you been, Mr. LaBelle?
I stay in Ypsilanti, Michigan, close to my doctors. I have
Well,
epilepsy.
I hope you have some money, else, you know, you've been playing with us for 6 years here. If you don't have the money to pay this right now, you are going to go to jail today, young man.
Judge, Mr. LaBelle's been having some issues with regard to his finances and stable residence.
Does he work?
Currently, I believe he's not working.
Why aren't you working?
I don't have transportation or any way of getting around. With my epilepsy, they took my license away. And I stay with my dad right now because he helps me getting back and forth to my doctors.
Mr. LaBelle, doctors for what, sir?
Epilepsy. I started having seizures around 5 years ago, 6 years ago. That's why I lost my job. I was actually a carpenter.
Officer Goldsmith, your name?
Corporal Goldsmith, Flat Rock Police Department, sir. Your Honor. Good morning.
Good morning. I'm gonna ask you to take your hat off, please, too, Corporal.
I apologize, Your Honor.
That's all right. What time did you get him? What was he picked up for and where and for what?
We picked him up for from Sumter PD on a warrant.
They were coming back from a Easter celebration, Judge. His father was driving and he was going too fast. He was pulled over. The officer asked for his identification in the passenger seat. He provided it. They did see he had a same.
When's the last time you worked?
It's been several years. Just not being able to drive has been really tough finding any employment, especially like in the location I'm at. It's just, I live in the middle of nowhere.
You live in Ypsilanti, you said, right?
Yeah, but it's like it's Ypsilanti, but it's like in like farm town in Ypsilanti. It's like it's Pittsfield.
Who do you live with?
My dad.
And he can't take you to work?
My dad does septic tank service, so he wakes up at 7 o'clock in the morning and then doesn't get home till about 5-6 p.m.
And you don't have transportation because?
My dad drinks a lot, sir.
Judge, yes.
And he's
seizures, Judge. And he's unable to drive. He just started getting medicated. And I believe he just got cleared to get his license back so that he can actually drive himself. Isn't that correct?
February 28th, I just got cleared to drive again for the first time in 6 years.
You have any money with you today?
I do not, sir. My father is willing to help with the payments.
Why don't you call him up right now? Corporal, let him use the phone. call them up, see if you can come up with $200 and I'd be willing to waive some fines here. But I'm not gonna just release you. I'm sorry. You're gonna have to make those calls and we will go from there. Do you have any questions for me?
No, I don't. I appreciate what you're doing.
All right.
And you're doing your job. You know, that's all you can do.
Thank you. All right.
Yep.
We'll let you make a call. And Corporal, will you call us back or communicate with? I don't know who I want.
I can't hear you, Your Honor.
John, would you communicate with Corporal Goldsmith and find out when this gentleman's called his father and what the story is, will you please? And then we'll call you back and we'll call them back.
Can I appear on Zoom? I've got another in custody for Judge Hessen.
Go ahead. Yeah. Yep.
Thank you.
All right. Riverside Townhomes versus Kim Morgan, 2601289.
What?
Riverside Townhomes versus Kim Morgan, 2601289.
I'm here, Your Honor.
Mark
Your
Landa for
name?
the plaintiff. Good morning, Your Honor.
Kimberly Morgan.
You're not driving, are you, Mr. Landau? Mr. Landau, pull the car
Sorry,
over
Your
right
Honor?
now.
Your Honor, I'm not driving. Would you
Pull
like to see
the
my driver?
car over. Pull the car over. Mr. Landau, pull the car over.
Judge, I'm sorry, can you hear me?
Yeah, I'm not gonna handle a case where people are driving. You're a lawyer, you know better. Pull the car over.
All right, Judge, we will right now. Pardon me.
All right, do I have Salters Realty here? And Mr. Ingram?
I don't think the manager's checked in and Mr. Ingram is still here, but he may be making contact.
Resolve this, Ms. Sineski?
Yeah.
Come on up here. Kathleen Sineski versus Dylan Demmer, 2600470. Do you have did you guys, let me hear your names, please.
Captain Sadesky?
Your name?
Dylan there.
Has this been resolved?
Yes.
And what are the terms?
The terms are, he's gonna pay $15.95 for January rent, $75 late fee.
Hang on one second. Okay, let me just. $15.95 for January rent, $75 late fee?
Yes.
Okay,
And then he's gonna pay the balance of the proration, which was $25.33.
okay,
And he had a missed water bill in December for $180.40.
okay,
Then his final water bill was $110.70.
okay,
And he had 2 service calls for the heat and the garbage that was left out at the curb, which I have my contractor here that I sent over there for $80 service call twice, so $160.
Did you add all those up?
Yes,
What is the total?
I come up with $2,146.43.
Do you have a proposed consent judgment by chance? Is that what you're agreeing to, sir?
Yes, sir.
Is to pay $2146.43?
Yes, sir.
Jennifer, can you bring me a consent judgment, please? I'll fill it out for you guys when I get a minute. You can both read it, make sure you understand it. I'll hand it to you. You can both sign it. I'll call the case. We'll go from there, okay? Thank you. Ms. Sineski and Mr. Dillian, I'm checking the box here on the bottom. I'm just indicating defendant has vacated property. This is strictly for money damages, okay? So I've got inserted here 2146.43. If the two of you agree to it, sit down and read it. And that's it. And you've gone into the property and looked.
Yeah,
So everything else is in order.
yes.
So you guys can, but signed, put X where you need to sign the date. And let me come back to Mr. This is not a good deal. John, what happened with the?
Gina took the spot. You need me to grab that?
I want to call this case with this young man here.
I'll get it.
Mr. Ingram, are you ready?
I believe so, Your Honor. I do have a
Salters
representative.
Realty versus Travis Hurst, 2601196. Mr. Hurst here, you guys?
Granting for plaintiff.
Don't go in. Is Travis Hurst here?
No, Your Honor, defendant did not appear.
You could take a default on this. Mr. Ingram?
Understood. This is a termination of tenancy matter, Your Honor. Given the fact that service was perfected, at this time, we would take a default possession judgment with a
Writ date April 16th, correct?
Correct, Judge.
You can submit your judgment. South Point versus Marquetta Brooks. Oh, wait a minute. I don't have that. What's your other ones, Mr. Ingram?
I've got the Brownstone cases. If you want to circle back to Rodriguez, I do have a representative
Brownstone
here.
Square versus Nelson Rodriguez, 2600939.
Brent Ticker for plaintiff.
Your name, sir?
Nelson J. Rodriguez, Your Honor.
All right. Did you guys talk on this?
I tried to contact him, but he didn't answer.
Mr. Ingram, what is your position here?
Well, this is defendant's motion. He needs
I
to
know.
show just cause or meritorious defense, and I'm not sure that he's done either of those things. He did have some questions. I do have Mr. Ed Amati here to testify from the property if he would like to present those questions again in terms of, I believe, the balance that was owed.
I didn't have questions regarding the balance, sir. My question was, why would they claim that I owed rent from these back as
Mr.
January
Rodriguez,
when that wasn't
right
done?
now, they gave me a judgment for 12/29/79. It looks like. Let me double check. Yeah, and I signed that on March the 16th. I don't find any of your arguments persuasive so far. Just to caution you. They perfected service. I don't know if you live there. I don't want to know, but you're responsible for taking care of the rent.
And
If
it
there's-
was brought up to date on March 2nd, which they continued to file paperwork. They had claimed that the rent was owed from as far back as January, which was not the case.
We have somebody here from Brownstown Square Apartments.
Mr. Ed Amati is here, Judge.
Yes. What's your name, sir? Your name?
My name Human Etamadi.
Are you the manager of Brownstown Square?
Yes, one of the managers here at the property. Yes.
Well, you tell me what we have here. What he's saying, you guys didn't credit him properly.
Yeah, we have applied all the payments that he has paid so far. The amount what we had on the judgment was correct, and everything was applied properly.
Your Honor, if I may?
Yeah.
On the copy I obtained for their complaint, their original complaint, it says rent is paid through December 31st. That is incorrect. Rent had been paid through January 31st. It says the amount that was due was $1,050. That is also incorrect. It would have been $1,025. On your judgment that's the one I did receive. They said the rent amount is $900. That is incorrect. My rent amount is $975. Other monies due, they claimed $140. They never stated for what that was for. The only month
that was late fees.
The late fees that they include of the $975, they include a $50 late fee, which would have made it $1,025, not $1,040, which is what you get when you combine those two.
Wait a minute, they had court costs. How much did you think you owed in rent? They said $900 on here.
Well, I owed $975 plus the $50 late fee, and that was paid on March 2nd. They continued with this paperwork, even though I brought it up to date.
Judge, this is a rolling balance, and he owed at the time of the judgment. What he's quibbling over in terms of these numbers, I don't see that speaks to just cause or meritorious defense. If he has some sort of ledger item the time to go over that would have been at the hearing, but right now, we're just only issue as whether or not he's presenting just cause or meritorious defense in terms of his motion.
But if you are claiming that my rent was paid to December 31st on your original claimant, that is incorrect. That's false. My rent was paid up
There
to
may have been
January
payments
31st.
paid after that was filed, sir, but you had a balance
No, sir.
on
No,
the day
look
of
at the
court.
date it was
Wait a
filed.
minute, Mr. Rodriguez. Wait, Mr. Ingram.
The only thing that matters is that he owed at the time of the judgment, which he did, and we stand by the numbers that we submitted to the court.
How much do you think you owed at the time that the judgment was entered on March 16th, Mr. Rodriguez?
Right now, I cannot tell you
No,
because
I
I
didn't.
don't know
Whoa,
what month they're claiming.
whoa.
Oh, what I owe at the time of the judgment,
wait.
only the time.
Wait. I asked you, as of the date that I entered the judgment, March 16th of 26, what do you think you owed?
$1,025, which would have been the $975 rent plus a $50 late fee, only for the month of March, for that same month.
Well,
Now,
I
if
don't need
there's
to hear all
additional
that.
fees-
Hang on.
Sorry,
Just give me a straight answer. How much do you think you owe?
$1,025, and I don't know what fees they added after that they said.
Well, they added on other money due, which was late fees, and they added on court costs and statutory attorney fees. Actually, truth be told, I'm not sure you're not telling me in so many words that you owe more than this judgment's worth.
I wouldn't know because the 140, I don't know what that's for, Your Honor.
I said late fees.
Okay, so with the late fees, it's $975 plus 50 is $1,025. That includes the late fees.
They had two late fees of $70 a piece for a total of $140 is what they told me on March 16th.
Yeah, according to my lease, the late fees are $50.
Is that true, Mr. Ingram?
I would have to look. Mr. Edamati should be able to answer that, though.
Okay, the late fee is a $50 late fee and also a $15 late fee. It's $65 altogether. Maybe that's where he's making making an error. But
You guys told me there were 140 in late fees. I don't know if it was 2 months, 3 months. I assumed it was 2. I could be wrong. Maybe it's parts of 3 months. I don't know. Can somebody tell me?
Here's a copy of my lease, $50 late fee.
It's
nothing more on any of the pages.
okay. The first late fee is $50. The second late fee that is there is about $25, and that was added back in February 16th. So the total late fee, the $140, is accurate because he
Okay.
haven't paid for 2 months.
That is what I'm telling you is incorrect, sir.
All right.
When
Well,
you filed this
hang
paper,
on, Mr. Rodriguez. You're talking nickels here. You really are. You didn't show up. We provided proper notice. And now you want to stop this. So I'm not going to do anything here. I'm denying your motion to set aside the default judgment. There is no good cause for failure to appear. And frankly, I don't see where you have a meritorious defense. So I am denying your motion to set aside. Actually, your motion is to stay the eviction.
that's all I need so that I can pay my rent.
Well, you
That's
should
what
have
I
thought
was
about,
asking them for.
stop. Don't start arguing with me or raising your voice with me.
Sorry, Your Honor.
Do you have today this judgment amount of $1,229.79?
I don't think so. I have it today, Your Honor, but I should have it by the end of the week.
Well, you only had until the 26th to come up with it of March.
When I spoke to them about paying it, they said if I don't pay it by then, I then would have to pay both months at the same time.
Well, I can't solve that for you.
I understand, Your Honor.
I'm sorry. You should have come up with the money when you were supposed to.
Your Honor, I wasn't 2 or 3 months late like they claim.
Sir, you're talking about pennies. Whether these late fees were supposed to be 100 or 140, I'm satisfied that they're charging you properly for late fees. I put caps on late fees, and that's that.
If I may, I'm not arguing the late fees, Your Honor. I'm arguing the time.
Sure.
The time.
I'm telling you, I'm denying your motion. You're going to have to talk to them or vacate. I'm not staying the eviction. I'm sorry. I wish you well. Thank you. Good luck. Kathleen Sineski versus Dylan Demmer.
Thank you,
26000470. Everybody's name.
Dylan Dem.
All right. Did you sign and read and understand this consent judgment for money for money damages only? Mr. Demmer?
Yes, sir.
Ms. Sineski?
Yes.
And you understand it amounts to 214643, sir?
Yes, sir.
And you agree to pay that?
Yes, sir.
And you understand that's for money damages overall, correct?
Yes.
And you vacated the property, correct?
Yes, sir.
You agree with that, right, Ms. Sineski? And did you sign and read and understand this document as well, Ms. Sineski? All right, so I'm going to order this money judgment here. I'm going to let you guys go down the hall and get your notice, and you're all set. I wish you well. Thank you.
Thank you.
All right, let's go back on John. This seems to go down those two. Let's go back on Roger Allen LaBelle, 19F231-701. Mr. LaBelle, your name.
Roger Allen LaBelle.
Corporal, your name again?
Corporal Goldsmith, Flat Rock Police Department.
All right, what did you find out?
I can make the $200 payment. I have my mother and grandmother coming up here. It's going to be after my grandmother has cancer. So she's going in for a treatment today. She's going to come in around 3 p.m. and then my mom's going to come in and make the payment for me.
Okay. So
if that's
3 o'clock roughly?
Yeah, it'll be after the treatment at
Where's Mr. Gaith? Mr. Gaith, are you out there? South Point Square versus Marquetta Brooks, 26019-01290. Ms. Brooks, your name, ma'am?
Marquita Brooks.
All right, you have to start your video, ma'am.
Oh, wait, sorry. Marquita Brooks.
All right, good morning to you.
Good morning.
Do I have Mr. Landau out there, Jennifer?
Judge, I don't know if he's. I'm looking through the breakout rooms to make sure he's not in one.
Do I have Juliana Jones here?
I don't have Miss Jones checked in. Mr. Landau's audio is connecting. We're just waiting for it to connect.
Mr. Landau, your appearance.
Mark Landau for the plaintiff.
You guys, where are you? Where are you, Mr. Landau?
I'm here, Your Honor. Good morning.
I know, but where are you?
I'm en route to Indianapolis to go see the Final Four, Judge.
To see what?
The NCAA Finals.
Are you pulled over, Mr. Landau, or are you still traveling?
I am pulled over, Judge.
All right. Ma'am, did you listen to and understand the rights on the video?
Yeah.
Yes, Your Honor.
And do you wish to speak to a lawyer or make an application for funding? Ma'am?
No, okay, I'm sorry. I got confused because I heard someone else speak as well. I didn't know if you were talking to me or.
Talking to you.
Okay.
I don't know what's going on today, really.
Okay. No worries. No, I already had the conversation with the attorney.
But how much is owed on this, Mr. Landau?
Your Honor, Ms. Brooks owes $911.91 in rent, no late fees at this point, $182.04 in court costs, total is $1,093.95. Oh, I'm sorry. You know what, Judge? I'm looking at the wrong paperwork. This is Miss Morgan.
No, because you're in a car. Because you're in a car. You shouldn't be in a car. You should have got somebody to handle these. Here's what I'm doing on all of these. I'm calling all these cases: Southwick versus Marquette, South Point versus Marquetta, 2601290. I'm adjourning this to the 12th, Jennifer, or 13th rather. Give me a time, please.
Judge, how about 11 o'clock?
11 o'clock. South Point versus Juliana Jones, 2601291. I'm adjourning this to April 13th at 11 o'clock. Then I have Riverside Townhomes versus Kim Morgan, 2601289. I'm adjourning this to April the 13th, and that's going to be at 11 a.m. Then I have, I think that's it for you. So that's what I'm doing on those. Do you have any more, Mr. Landau?
That's it, Your Honor.
I tell you, I don't like this. I'll be back in 5 minutes. Thank you. Stay seated, everybody. Stay seated. All right, now we're going back. Where's Mr. Gates? Come on up here, Mr. Gates. This is what I'm willing to do on Mr. LaBelle. Roger Allen LaBelle, 19F2317101. All right, Mr. Gates, your name?
Good morning, Judge. I have to get turned back from the phone. Please be adjourned.
Mr. LaBelle, your name?
Roger Allen LaBelle.
So look, I'm willing to cut these fines down for him. He says he's going to pay 300 or 200 by 3 p.m. I'm just telling you, if he wants to plead guilty, I will sentence him to $200 or 20 days, and he'll pay that at 3 o'clock, and he'll be released. If that's what he wants to do.
Mr. LaBelle, you understand that if you plead guilty today, the judge, you heard what the judge said?
Yeah, it was $200 or 20 days.
Correct.
Yeah, I can pay the $200.
That needs to be paid by 3 o'clock this afternoon.
Yes, yes. My
Let me
my
take,
grandma,
hang on.
Yep.
Slow down. If you plead guilty, I want you to understand that I'm going to incarcerate you 1 day for every $10 owed, so you could get 20 days. Do you understand that?
Yeah, if I
hang on, let me finish. Just let me finish.
Yes,
though.
sir.
You understand?
Yes,
if you
sir.
pay that, you're not going to have to serve any time except till 3 o'clock. Do you understand that?
Yes, sir.
All right. If you want to plead guilty to that charge, failure to pay $200.
Can I ask a question, Your Honor?
Sure.
I just want to make sure I understand correctly.
You pay the 200 by 3 o'clock, you're going to be done. If you don't pay that, then you're going to serve 20 days. I'm going to waive the balance. You owe another 100 and
Yeah, that's what I want to do.
Another 82, I believe, plus a clearance fee, but you'll still have to pay the clearance fee too. Do you understand that?
Yes, sir.
All right. Do you want to plead guilty?
Yes, sir.
The charge you failed to pay $200, $282, I believe. How do you plead?
I plead guilty.
Did you fail to pay?
Yes.
Anybody force you to plead guilty?
No.
All right, I'll accept your plea. Defendant to serve 20 days or pay $200 If you pay it today, you'll be released today. If not, you're going to serve 20 days. Balance waived, but you still have to pay your clearance fee on this, okay?
Yes.
So when you get released after the 200, you should get your 40 bucks up here. And that will be your clearance on this ticket. And then I don't know what the extent of your record is, good, bad, or indifferent on the rest, but at least you're moving toward getting your license, okay?
Yes.
Good luck to you. Thank you.
Thank you, Your Honor. You have a wonderful day.
You. Okay, is Derek Taylor here? Brownstown Square versus Derek Taylor. This is 2601308. Mr. Ingram, your name?
Brent Tinger for plaintiff. Hello again, Your Honor.
Is Derek Taylor here?
Yes, Judge, it looks like he moved back to the breakout room. I'm getting him right now. There he is.
Mr. Taylor, your name? You're muted.
Derek Taylor.
Did you listen to and understand the rights, sir?
Yes, Your Honor, I
Do you
did.
do you wish to speak to a lawyer?
No, sir.
All right. Do you wish to apply for funding?
No, sir, I do not.
Okay, Mr. Ingram, what do you want to do here?
Well, right now, the balance that I'm showing is $809.79 plus $150 late fee. So that's $859.79. There's cost of $189.79 for a total of $1,049.58. So my question to Mr. Taylor would be, do you think you can get that paid in 10 days, sir?
Sir, yes, I've over the weekend, I think on the 4th, I paid $775. So I only should own the balance of that.
Okay, what do you think the balance is then?
Brownstown Square, Mr. Adamati, you're here from Brownstown Square. Tell me your name again, sir, and tell me whether he made that payment.
Yes, this is Human. I'm checking right now to see for he made a payment
On the 6th.
on the 6th.
He's got to convey this to your lawyers. I feel like a babysitter here. Come on.
We just received the payment, sir.
Well, he said over the weekend. When did you pay it, Mr. Taylor?
That would have been the 5th, I believe it was.
Today's the 6th, so that was yesterday. Do you have the payment? And if so, how much is it? Mr. Adamati?
Yes,
Talk
sir.
to me, please.
$775, sir. Yes.
That's what he paid?
Yes.
So why wouldn't you convey that to your lawyer? I don't care how you do it. Text, email, phone call. Come on.
We just updated our files. So
all right, it's
we did send it.
11:35. You guys should know when you have cases here as to who's coming in. And if you get a payment as to one of them, you got to notify your lawyers. I can't tell you, I'm getting so close to requiring every property manager to come in here on every one of these landlord tenant cases. And I'm going to start, if you guys don't do a better job of conveying to your lawyers what payments were made. I'm not going to take breaks and have people call people, and it's ridiculous. So what's your total balance now? If he paid 700 and how much did you say? 749? I shouldn't have to do this. I'm the judge here. I shouldn't have to do this. How much was paid, sir?
$775. The balance is now $84.79.
See, and like if he wasn't here and I got Mr. Taylor telling me this, there's going to be some mistakes. So if he only owes $84 plus the cost, is it, Mr. Ingram? Is that what you're gathering?
I'm assuming, Mr. Adamati, did you include court cost in that calculation, or did you not?
No, because we didn't have that yet.
Okay, so that's plus court cost, Judge. So it's $189.79 plus $84.79.
And what about the $50 late fee? Since he paid it, there's no late fees?
No.
So what's your total now, Mr. Ingram? You got 84 and 89.79. or $189.79. That should be $273.79. Is that true or false? I didn't have a calculator. I don't have.
I'm running it on my calculator right now, Your Honor, but
It's $273.79.
I have
So,
I have 274.58. But let me
well,
run
all
it
I got
again.
is $84 judgment amount and $189.79 in cost. That's $273.79. Am I missing something?
It's $84.79, the balance.
Exactly. So 84.79 plus 189.79 is
Yeah.
274.58.
Agree. I didn't have the 79 cents there.
That's what the judgment should be. And it sounds like he'll be able to pay it in 10 days.
So, sir, I can give you a writ date of the 17th, okay? You're going to have to pay it by next Friday, no later, or else you have to vacate, Mr. Taylor. You understand that?
17th, yes, I do.
All right. I wish you well. That'll be after hearing. Thank you very much.
Thank you.
Henry Isabel Colmenares, Brownstown Square versus Henry Isabel Colmenares, 2601309. Your name, sir?
Did you tell them? Go send the thing.
Hello.
Go tell them.
Your name?
Oscar Colmenares. Henry is
Well,
my father,
well,
but
who's
I am
Henry?
coupled with.
Who's Henry?
He's my father. He's working now.
He's working?
Yes.
I can't let you appear on his behalf.
But yes, I am the responsible to stay in the apartment. Actually, in the defense is Henry and all other occupants.
Who's on the lease here? Mr. Ingram, do you know?
Let me take a look. Give me just a moment.
I didn't quite understand you, Mr. Colmenares. You got a bit of an accent, and that's fine. I'm just going to ask you to repeat what you said slower and louder.
Pulling it up right now.
Is Henry Colmenares on the lease or not, Mr. Oscar Colmenares?
The person I see on the lease is Henry Isabel Colmenares, and that's it.
Are you an occupant of the property, Oscar Colmenares?
Yes.
Do you know anything about that, Mr. Ingram?
That I do not know. Mr. Edamati may be able to speak to that.
Yes. They made a payment and they do not owe any balance at this time except the court costs.
So that would just be $189.79 owed.
When did you guys make the payment? When did you make the payment, Mr. Colmenares?
I paid them in March 27.
Wait a minute. When was the payment made? I don't know. I don't know what to tell everybody today. When was the payment made?
I'm sorry, Judge. The payment was made at the end of March.
Okay, now wait a second. I want you to put yourself in my position for 13 seconds here. You're the judge for a second. Wouldn't you expect a landlord to convey to their lawyer that nothing is owed on the judgment before the lawyer starts bringing out figures and I drag people in here? I'm serious. This is ridiculous. If they made it on March 31, today's April 6th. If you guys aren't going to run your operation correctly, I'm telling you, I will not put up with this again. You're going to have to come in here personally. I'm going to line all you guys up and treat you like children if that's what you're going to make me do. All right. Do you agree that you owe the court costs of $189.79, Mr. Colmenares?
If we need to pay that, we don't have any problem with that. I can pay, but so I don't know because it's the first time that's happened for me. And actually, I have the paper here, but they say the January 31. But I pay 2 months in December for January and January.
Late in paying it. They'd already filed this, so I'm going to give them that 189.79. Writ date will be on the 17th. That will be after a hearing. Actually, I'm just going to enter a default judgment versus Henry.
Understood.
And you
We'll
can do
split the
after
order.
hearing versus occupant Oscar.
Got it.
Okay? So just make sure you pay $189.79 by next Friday, sir. Thank you. FC Stratford LLC versus Takesha Reeves, 2601296.
Good morning, Your Honor. David Fantera, behalf of the plaintiff.
Good morning. Do I have Takesha? There you are. Your name, please?
I'm Marte Hanna. I'm her son. I had spoke with the lady about 30 minutes ago in the breakout room. I don't know if she was my attorney or...
What's your name?
My name is Marte Hanna. I'm Takesha Reeves' son.
Hang on a second. Marte, how do you spell that? M-A-R-T-E?
T-A-E.
And your last name?
Hanna, H-A-N-N-A-H.
Okay. Where's she at?
She had cataract eye surgery this morning at 7 a.m. That's the only reason she's not here. She would have been here for any other. She would have been here.
What's this about, counsel? How much?
The rent that's owed at this time is $3,357.13. That includes.
Hang on a second. Did she not think to call and request an adjournment? I mean, I would have given her an adjournment if she was having cataract surgery, but she can't just not show up and expect me to say this is okay. And I can't let you listen.
Sorry,
I can't let you represent her.
Yes, I understand.
You're not a lawyer, right?
No, not at all.
Okay, I can't let you represent her.
Okay.
What do you want to do, Mr. Fantera?
I'd like a default judgment. They moved in at the end of January and have made no payments since they moved in. The total balance, including a $75 late fee for March and $50 late fee for April, is $3,357.13.
The rent to retain first.
Okay, sorry. I apologize. $3,042.13.
That's just in rent.
That's just rent.
Late fees, you got at $125, right?
$125, and then court costs of $190.
So what's your total again?
$3,357.13.
There's nothing I can do, Mr. Reeves. I don't know what to tell you. I can't let you represent her.
I wasn't trying to represent her. The lady I talked to before, she said that you can adjourn it because it only takes her 7 days to for she be able to remove the eye patch because she plans on playing it. It's just been her by herself. So, but she plans on paying it.
Well, he just told me you guys hadn't paid anything or she hadn't paid anything since they moved. Mr. Orlando, I need you to mute, please. He just got done telling me that you guys haven't paid a nickel, right, Mr. Fantera? Did I understand you correctly?
That's correct. They paid money when they moved in, but have not paid anything since then.
She should have called for an adjournment. There's nothing I'm going to do. Writ date will be April the 16th. So
Okay.
she's going to have to pay up that amount by the 16th of April, or a writ will issue, and it's 3,357.13. Okay.
Okay. Thank you so much.
Thank you very much.
I'll submit a judgment, Your Honor. Thank you. Have a good day.
Thank you. You too.
And that, my friends, is how you get yourself evicted real quickly by just disregarding your court case and letting your grandson show up instead. It seems like somebody just wasn't really feeling the whole paying rent thing. You know what I mean? All the way around from the get-go. What you gonna do? Look at that one. I mean, how do you even explain something? And the poor kid trying to do the best he could for Nana. I give the kid props. But man, all these cases tonight, serious cases to Mondays, ladies and gentlemen. starting with those PPOs. The Love Boat was strong with the first half of the presentation, and then we got right into Judge Dad, who just had a day full of all of it. I mean, he couldn't even depend on the lawyers who normally appear in the court, who know the rules, to be following the court rules and not, riding in a car on the way to the Fantastic Four. I mean, the Wild Four, whatever that baseball term is. I mean, it's college basketball. I'm being funny, but still, God, you know better. Nobody has to tell you. You'll do better in the future after you see your team play, and hopefully they win. Ladies and gentlemen, we are going to Hutch's after the show tonight. Redirect is already set up. I do want to say a quick thank you, very big thank you to Wixom, Lisa the cat mom. Wixom, I've got to say thank you to you like 2 or 3 times over here. But Muddy Magnolia and Suave both celebrating their very first super chats in a live stream tonight, ladies and gentlemen. Thank you so very much for that. Nina, coming from out of the blue, thank you. And thank you, Lisette and Felix and Charlene and Kimby and Becky and Bro and Mama and Rhonda. I can't even name all the people. It's really not even fair because I'm going to have to scroll up and I'm still going to not remember half the people whose names I've already said, like Marty and Big Tiff Dog and Legal Keys, and Math Girl, and Becky, and Soldier. Thanks for being here. Thank you so very much. Chat's been amazing. We had a couple of little hiccups taken care of by Mama as always. Keep Mama happy. Everybody's happy. You know how it goes. So, I guess that's it. I don't really have anything else. Oh, hey, if you do still feel inclined, I do this every single night of the week. I don't know if you know that. 8 p.m. Central Time, 9 p.m. Eastern Time. Come by and hang out. We also do Saturdays. So, just want to let you all know I'm expecting you all to show up this Saturday. Go ahead and make plans if you would. Cool. Office space call out for you there. Ladies and gentlemen, I am your lone wolf Uso. I'm done. I am out. Oh yeah. And for those of you who know, this is a very special shout out to the, we normally we're talking about Ferris Bueller's Day Off, his movie call out references, but tonight I have a very special thing for everybody, for those of you who hung around, and enjoy.
4 weeks, 20 papers, that's $2 plus tip.
Gee, Johnny, I don't have a dime. Sorry.
Didn't ask for a dime. $2.
Well, it's funny. See, my mom had to leave early to take my brother to school and my dad to work because...
$2. Cash.
When I used to think about...
Whoa, stop. I messed that up, but that's not the only one. This is the most important one. Ladies and gentlemen, a philosophical question for all of you.
Let me ask you something. When you come in on Monday and you're not feeling real well, does anyone ever say to you, sounds like someone has a case of the Mondays?
No. No, man. Shit, no, man. I believe you get your ass kicked saying something like that, man.
Huh.
Yep.